Assault and battery crimes are the most common violent crimes here in California. It can range from misdemeanors all the way to felonies where you could be subjected to a lifetime sentence, meaning you could spend the rest of your life in prison if convicted of certain offenses. Many people really don't understand the differences and the similarities, what the law requires and what's at stake, and what are some possible defenses. In this video, we're gonna break down the differences between assault and battery. We're gonna talk about defenses. We're gonna talk about possible punishments. And we're gonna talk about the things that you need to know if you or a loved one are facing these charges to protect your freedom and protect your future. You gotta know your rights. Welcome to our in-depth look at assault and battery charges in California. My name is David Shapiro. I'm a San Diego-based criminal defense attorney. I've been doing this since 2007. Today, we're gonna be covering the definitions of assault and battery, possible penalties if you're convicted, certain defenses, and some lesser offenses if charged with more serious offenses under this battery and assault formula. Whether you're facing charges yourself, you're doing some research for a loved one, or you just really want to understand the differences, I hope you find this video useful in understanding the differences and the importance of those differences between assault and battery here in California. The first common assault charge we want to talk about today, assault with a deadly weapon. In California, that can be found under Penal Code Section 245A2. And what that is breaks down as simple. Assault with a deadly weapon, meaning you applied force or acted in a way that reasonably could be expected to apply force to another, and you used a deadly weapon. You don't have to actually make contact with that person. And what are some examples of deadly weapons? Could be a bat, could be a gun, could be a knife, could be a lot of different things. The reality of the situation is it's the same offense as simple assault, just that you used a deadly weapon. There's other enhancements that get attached to it. If you personally used the weapon. Now, I know that sounds kind of ridiculous, right? How could you assault someone with a deadly weapon if you didn't personally use it yourself? Well, there could be accomplice liability. You could be responsible maybe for the actions of somebody else. But the bottom line is assault with a deadly weapon is a serious charge. It is a strike offense in California, and it needs to be taken seriously. And the best way to do that is to make sure you understand the law and protect your freedom by keeping your mouth closed and letting your lawyer do the talking for you. Another assault offense that we see a lot, particularly in San Diego, Penal Code Section 245A4. Now, there was a time when assault with a deadly weapon and assault by means of force likely to produce great bodily injury were combined in one penal code section. Now, 245A4 is strictly limited to assault by means of force likely to produce great bodily injury. Doesn't necessarily need to produce great bodily injury, just that an amount of force was used, or at least tried to use, and that force could have reasonably produced great bodily injury. So where do we see 245A4s allegedly committed? Well, we see them at bars, we see them at sporting events, we see them in domestic disputes, and it's usually more than a simple shove. It's usually more than a slap. It's usually more than an errant punch or something that pretends to look like one. It usually is in a pretty serious fight where people are throwing hands. Now, we talked about how 245A4 talks about with the intent to cause great bodily injury. It doesn't necessarily require that great bodily injury be proven, but what if it is? Great bodily injury is defined under Penal Code Section 12022.7. And if great bodily injury is found, right, that's not something that's just gonna last for a couple of hours, maybe even a couple of days. It's something that will linger for a period of time. And there's a really long definition under 12022.7 of the Penal Code, which outlines what is and what's not great bodily injury. Now, if someone suffers great bodily injury as a result of an assault, what does that mean as it relates to potential punishment? What does that mean as to how a prosecutor and how a judge may treat that situation? Well, it means a lot, because if great bodily injury is found, you're subjected to at least a 3-year additional term. Could be 5 years, could be 25 years, depending on who the alleged victim is, what the extent of that injury is. Equally, if not more important, is the fact that no matter what the extent of the great bodily injury, if that 12022.7 allegation is found true, a felony now becomes a violent felony and all the consequences that come with that type of conviction. In this segment, we want to talk about two other offenses that we see quite frequently in San Diego. Battery causing serious bodily injury can be found under Penal Code Section 243D. Now, often we'll see that paired up with the 245A4, assault by means of force likely to produce great bodily injury. And at first glance, you may look at that and say, well, what's the difference? Well, there's a couple. Under 243D, it actually implies and is assumed as charged that serious bodily injury was in fact inflicted. Remember, under 245A4, it just has to be an assault with the intent to commit great bodily injury or likely to produce great bodily injury, not necessarily that the great bodily injury actually happened. So under 243D, if convicted of that, that is a serious felony in and of itself. It is a strike felony. So there are some differences to be aware of between a 243D and a 245A4, although oftentimes they are quite frequently charged together. In this segment now, we really should break down 245 Section B of the Penal Code, and that's assault with a firearm. And this is a very, very serious charge, particularly in San Diego, how it's prosecuted, because under California law, assault with a firearm, that's when you start looking at double-digit sentences, let alone if you actually discharge the firearm, right? Because the first premise of assault with the firearm is that you assaulted someone and used a firearm to basically effectuate or to facilitate that assault. But it doesn't always require that you actually discharge that firearm. Okay, so assault with the firearm in its most basic sense could be if you just point a firearm at someone, right? If it's loaded, it could be an additional penalty. God forbid you actually discharge it, forget it. You're talking about 5 years, 10 years, 25 to life, so on and so forth, depending on what happens if you actually discharge the offense. Now, one thing that's really important to understand, right? We just talked about that if you actually point a firearm at someone, whether you discharge it or not, that's sufficient for assault with a firearm. But let's say, for example, if you just show someone a firearm and you don't necessarily point it at them, well, that's misdemeanor brandishing of a firearm. So you see the big differences between what is a misdemeanor brandishing, a punishment where you could be facing no more than a couple of months in county jail, and assault with a firearm where you're looking at a significant amount of time in state prison, not to mention a strike felony on your record. So it's really important to understand the differences, and more importantly, to make sure you surround yourself with a legal defense team that understands those differences and really fleshes out those facts to make sure that what can be proven gets proven. So one thing we see a lot is district attorney, prosecutor comes out of the gate hot. We get a case and they're charging our client with a 245B, assault with a firearm. We're looking at it, we're like, wow, that's a really serious case. But when you actually peel back what is alleged to have occurred, a lot of times even just in a police report, it's like, this isn't a 245B. This is at worst a brandishing under Penal Code Section 417. Now, why is that significant, right? It's significant for a number of reasons, not the least of which brandishing is going to fall in the misdemeanor realm, not a serious strike felony realm. Not to mention the fact that all these allegations that get attached to a 245B, if the firearm was loaded, if the firearm was personally used, all those things are inapplicable if we're dealing with a simple brandishing. Now, sometimes witnesses will say, oh, he pointed the gun right at me. But upon further review, we'll say, you know what? It wasn't really pointed at me. It was just visible, or it was in his or her lap, or they slammed it down on the table. Well, that's not a 245B. That's at worst a brandishing, which requires that showing someone a weapon be done in a rude, a threatening, or an angry manner. Really, really important difference here between a 245B and a 417 of the Penal Code. Finally, now we're going to cover one last offense, and that's Penal Code Section 246.3, negligent discharge of a firearm. What we see a lot of times is situations where, say there's a bar fight, or there's an argument, or someone's actually trying to diffuse what could be a real lethal altercation. So what do? They go to their car, they grab their gun, and they start firing off a few rounds in the sky. Well, that's not assault with a deadly weapon, but it is negligent discharge of a firearm. You're releasing or discharging a firearm in a negligent manner, right? Where someone could get hurt. That's not necessarily your intention, but you're doing it negligently. Other times we'll see situations where someone could be in their house or their apartment, they could be cleaning a gun and it goes off. Well, it's no one's intent to discharge that firearm in that situation, but it's certainly negligently discharged, and we see that a lot of times as well. Now, negligent discharge of a firearm could be filed as a misdemeanor or as a felony. There are certain mandatory minimum sentences to be aware of, but a lot of times a good mitigation as to why you had to do what you're alleged to have been doing could go a long way in securing a favorable outcome. Now, what are some legal defenses that we see to assault and battery charges? Well, the first is factual innocence. It wasn't me. I wasn't there. I have an alibi. Maybe I was there, but maybe it's a cross-racial identification. Cross-racial identification talks about when you have someone of one race trying to identify someone of a different race, the likelihood of them getting it right goes down considerably. That's pretty well accepted. Now, on the opposite end of the spectrum is, hey, you were there, you did what you're accused of doing, but you have a valid legal defense, self-defense, or defense of others. Now, a lot of times people get themselves in trouble by talking to the police, by making statements in the public about why they felt they needed to do what they ultimately did. And the best defense might not be that, hey, nothing happened, client didn't do it, there's an outright defense. It may be, yeah, something happened, but you know what? It's not great bodily injury, as the law defines it to be. Therefore, it should be a simple felony, or it should be a misdemeanor, not a strike felony. And other times, it could be an intent issue. That was not the intent. Maybe it was an accident. The most important thing, though, when assessing what your viable defense is to make sure you don't close doors to those defenses by trying to take matters into your own hands, by trying to talk your way out of a situation, by speaking to police, wherever the case may be, without first talking to a locally experienced criminal defense lawyer that knows what he or she is doing and can prepare you accordingly to make sure you avail yourself of the best defenses out there to your assault or your battery charge.